Okay, just by way of a little background here. So I did get a question regarding an individual who had a pending case, a pending criminal case in court, and they were currently represented by an attorney. And that creates a problematic situation when they're wanting to know what to do about their case, because once somebody has an attorney and they have a case that's already filed, everything they tell their attorney is confidential and it can't be revealed. So it's protected under that attorney-client privilege. So, they tell the attorney what happened in their case, and that only stays between the individual and the attorney. Once they start going outside that and telling friends and family members what happened and what should I do? Well, then those people become potential witnesses because we're hearing their statement and it's not protected. So, I mean, usually the prosecutor's not going to find out about it. They're not going to know whether the defendant talked to the neighbor or not, but it's possible it could happen. The defendant might say, I did talk to my neighbor and my neighbor said this, and they go out and interview the neighbor about what the person said. So this is just a way of showing that once somebody starts to go outside of that attorney-client relationship and talk about their case, it starts to create a lot of problems. And this one person that we had, and things come up, this particular situation was the defendant, the individual, didn't believe that she was getting proper representation, that the case wasn't being properly investigated, that she wasn't happy with the communication that was going on with the attorney. That's an area that we might be able to offer a little advice on, as long as we can stop them from trying to go into the details of the case. A lot of times they'll want to tell you, hey, this is what happened. And you do get some individuals that are very talkative and want to tell you all the details, the nitty-gritty details, and why they shouldn't even be in the system, and I understand that, but it's important when that starts happening that we call a timeout and say, hey, look, we don't want to talk about the facts of the incident at all. We don't want to discuss that. You've got an attorney, and you should only talk to the attorney or that attorney's investigator, or if they have an expert witness or something, people that come within the umbrella of that attorney-client relationship. So that's what's important when somebody's coming to you and asking about a case. Well, then if they're asking you about a case, it's probably already been filed or something's happened. And so you just want to make sure that any advice that we might give is geared only towards, okay, well, we can tell you about how you can approach the judge and maybe tell the judge that you're not happy with your attorney. Or, maybe one of us could call the attorney and say, hey, we got a call from so-and-so, and just a heads up, we're not making any judgments one way or the other about whether this is accurate or not, but we want you to know that there are some concerns about communication. There are concerns about investigation and whatnot, just making it like we're just there to convey concerns that the client has. We're not presuming one way or the other that these are true or false or founded or unfounded. We're just trying to be a conduit for information there to try and improve communication. And sometimes that might be enough. It might be, oh, hey, I'm a family friend, or I'm close to this person, and I just wanted to let you know that she's expressing this, and hopefully if there are problems that they can be alleviated. The other thing, one thing that we can tell them is how to go about expressing their concerns to the court. So there is a way of asking the judge to provide another attorney if they are dissatisfied with what's going on. And the technical name for that is asked for a Marsden hearing. It's after a case called People versus Marsden, but it's oftentimes just shortened to a Marsden hearing, or it's just, Your Honor, I would like another attorney. I'm not satisfied with the work that this attorney is doing. I mean, that's enough to trigger the process right there. The judge will then, okay, you're asking for another attorney. And what happens at that point is the judge will basically clear the courtroom out. So it's very private. It's just the defendant and the judge and the court reporter and nobody else, the attorney, and not even the prosecutor. The prosecutor is excluded. So this allows the defendant to really get into things and talk about the case, talk about why the attorney is not performing properly, what the concerns are. And they have to, at that time, the judge will say, okay, tell me what the problem is here. Why are you concerned? And it'll be up to the defendant then to explain in some detail what the problem is. Well, I've tried to call a number of times. I never get a response. She always says she's going to do this or that, and it never happens. We're now 3 months, 4 months into the case. Nothing's been done. My witnesses haven't been contacted, whatever it is. And then the attorney gets a chance to explain or rebut anything that the client might say, to try and explain why the client's in error, or put things into context a little bit. And then the judge ultimately decides, well, okay, I'm going to either appoint a new attorney, or I'm going to, keep you guys together, and, hopefully we can work these things out. The judge will try and be like a marriage counselor or something, in some ways. It's like, you think we can do this or that? I mean, they're hesitant to want to split that up right away, unless there's a serious breakdown, unless it's clear the attorney is just totally engaged in some incompetence or malpractice, or there's just such a breakdown in relationship there that the two can't even talk. It's just like, okay, it's time to get another attorney. This is not working out. So that's the process, that whenever somebody is charged and has an attorney, that's really how one should approach it. Just stay out of the details. Let's just figure out what you can do here. This is what you can do. When next time you go to court, you can ask the judge for another attorney, and you'll have to explain, why it is you want another attorney. So you're going to have to be ready and have your details down, and you're going to be asked to make your case, essentially, why somebody else should be appointed. Now, if there, I guess that tends to be the situation that we have, it seems, right? I mean, we've had a couple of those where somebody's wanted help with their case. We shouldn't really, we shouldn't be out investigating the case. Well, I'll go talk to the neighbor and see what the neighbor says. That is really not something that somebody should do. That's for the attorney and their investigator to do. Now, it might be that, if we know of a witness that this person claims is a witness in the case, and we want to communicate that to the attorney, and we could call them and say, hey, Mrs. Robinson down the street supposedly saw this, and we would request that you go down and have that person interviewed while it's still fresh in their mind. That's something that could be done. We don't want to take on these things ourselves. We would just want to pass on information to the attorney or the investigator and make sure that that they're the ones that are handling those duties. Any questions about anything? I mean, there may be more general questions that we get about, the system. If somebody is not charged with anything or doesn't have a case, well, that's a whole different story. Then it's carte blanche. We can open up and talk about things. But the only time we really have that concern that we have to be very careful about not discussing anything is if there's a potential charge coming down the road maybe they haven't even been charged yet,
So I think, and if you could speak to that, because I think we do get that, or, I haven't directly, but I know others have, where there's a potential for a charge. And the other thing that I've noticed, that especially if you're talking about someone with not a lot of, necessarily not a lot of education, that it's hard for them to know where they are in the process, or we could use different terms. Like I remember one case where the person wasn't really sure, or wasn't really clear, was that in Tehama? Was that here? Was it, what was it related to? And so there's those murky areas too. But if you could speak to if a charge is likely, but we don't know what's appropriate for involvement of groups like ours.
Well, that's something that I would think one could get involved in. And if say somebody weren't charged yet and they weren't sure whether they were going to be or not, one could call the law enforcement agency that was involved. Let's say I'm assuming that this person might have been interviewed by police or sheriff's department or something. It might be possible to say, call up the sheriff's department and say, I'm a friend of Mary Jones and she was contacted by sheriff's department on this particular date and time regarding this. And, we're just wondering what's going on. Is there an ongoing investigation here? Are there charges that are going to be filed? Is there any information you can give us? And sometimes they'll blow you off and say, hey, we're not talking to anybody but an attorney. But sometimes a family member or a friend could call up and schmooze it a little bit and just try and get some information out of it, try and be kind. And we're just trying to find out what the next step here, what's going on. Are there going to be charges filed? And they might say, well, there's still an ongoing investigation and we'll let you know, we'll let her know or him know what happens. Or sometimes they'll say, we've already sent it over to the DA's office and there's nothing else we can do about it. It's out of our hands. At which point then one could call the DA's office and say, hey, what's up? Can you tell me anything? So there are ways of just finding out where something is in the process without talking about the details. If they know who they talk to, what jurisdiction, a sheriff. If they don't know if it's Tehama or Shasta, well, then you could call Tehama and Shasta and see, is there an investigation ongoing here? Mm-hmm. That's more of just kind of like fact finding, help, just how do I get so-and-so to court? I'm trying to make sure they don't miss their court date, or we want to make sure everything's cool here and you're not sending a letter to somebody then at an address that they're not at anymore. Just a helpful information gathering process where we're not really trying to dig into the details of the case and the facts and, investigation and trying to look into that. Mm-hmm. That does create a problem, because even if somebody is not charged and we start talking to them about the details of the case, then that could be, if they do get charged, then that's fair game. If the prosecutor finds out that you've talked to them, that's an iffy area, as I say.
One of the things you mentioned when you wrote back, that part of the iffiness was that if they say something that's different from what they said before, which, right. Many of us do all the time, something else comes up or I'm explaining it differently. And tell us about what's problematic about that.
Okay. Well, a lot of times despite the fact that defense attorneys always tell their clients, don't talk to the police. They always talk to the police. It just is human nature, No, it's a hard thing to say, I want an attorney, I'm not talking. Or somebody thinks, I can out talk these cops. They don't know what they're doing. So they make a statement and, their memories might be a little off, or who knows, you make a statement and so they have one statement out there that they've told the police, or that the police say they said. Hopefully it's on recording, but the police will say she said this. Well, she might go out and talk to somebody else. She might go to Eddie and say, "Hey Eddie, she told the cops the light was green," and she goes to Eddie, and the light was red, Eddie. I didn't, I stopped, and so it just, once that comes up, depending on how inconsistent the statements are, it could hurt the client if they're in court at trial and they've got inconsistent statements that are significant. Sometimes there's minor inconsistencies. We all do that aren't important. But if they find out that she made a statement to Eddie that's dramatically different than what she told the cops, well, that's going to come out, because they'll call Eddie in and they'll say, well, she told you that the guy that came after her had a knife in his hand or something, and she told us that you told the cops that he didn't have a knife, right? Isn't that true? It could be something along those lines, like she's
discrediting.
She might be discrediting her. Maybe she's making a self-defense claim, and she told the police that there was a knife, the guy had a knife, and then she tells Eddie that he didn't have a knife. And so it could be a major thing there. They'd say, well, you told Eddie that this assailant didn't have a knife. Isn't that true? And so that's a pretty significant detail, whether somebody had a knife or didn't have a knife as they're coming at him. So you wouldn't want that to occur. And I'm just throwing that off the top of my head, but
yeah.
If it was, well, he was wearing a blue shirt as opposed to a green shirt, that might not be that big of a deal. But any little, attorneys are always looking for any little inconsistency in different statements. And the more statements that are made, the more inconsistencies there are, and the more there's an attempt to question the credibility of the witness. That's trial lawyer 101 there. You're just trying to get as much discrepancy here as possible, and then the jury has to decide how significant these differences are. So ideally you only want just one statement, and you don't want to have all these different statements coming in. So even if somebody hasn't been charged, if they make a statement to somebody, that could still be used if they end up getting charged. So it is an iffy area to be aware of. If somebody thinks, okay, the cops showed up at my house and me and my boyfriend were into it, and let me tell you what happened. And it's probably wise just to say, let's not go into the details here, okay?
For your protection.
For your protection,
right.
Yeah. It's because I'm not an attorney you're talking to. Nothing that you say to me is privileged. Potentially somebody could ask me what you said, and they'd say, well, that's fine. I don't care. I'm telling the truth. But it's still, you're doing it for their benefit and for their protection. And you might just say, let's not talk about the facts. Let's try and find out what's going on here. Let's call RPD. Let's call the sheriff's office. Let's find out what's going on and see if it's an issue or not. They might say, no, we're not. We don't even think anything of this. We haven't even filed a report. It's just we showed up and that's it. So then you can put them at ease and you can say, okay, they say there's nothing coming out of this, and you're going to be fine.
Yeah. And we have a question in the chat, and another to circle back. There are two things that Lori said that I want to bring up. But early on, when you said like a person could call the person's lawyer, and I know in the communication we had before, one of the things that you suggested is to encourage the person to speak to their lawyer. I mean, is it preferable if they're comfortable for them to have that conversation? I'm thinking like I've worked at different places where this, like, here's what you do first before you, and I'm not thinking of the term first, but if the person's willing to talk to their own lawyer before some group jumps in and calls them
on
their behalf.
it's always best to get a lawyer involved if there's some issue that needs to be addressed, and not address an overall group about the
Mhm.
facts of the case. Is that what you were?
No, like if in this one case, if the person was concerned that their attorney wasn't serving them,
Oh,
and when you were writing back, if I'm remembering correctly, you suggested they speak to their attorney and say, "Hey, I'm really concerned. I'd like to have, I feel like my needs are not being met. Are you able to meet that?"
yeah. I
That,
mean, that's always the best course of action, to try and work it out between yourself and the attorney, and see if you, yeah, communicate your concerns, let them know what the problem is.
mhm,
Most of the time that's already happened. They've tried that and they feel like there's a breakdown.
mhm,
But so that would be the first piece of advice. Well, have you talked to your attorney and told them what your concerns are, and
mhm,
have they given you any satisfactory answers about that?
mhm,
That would be step one.
mhm,
And then step two might be, well, do you want me to give them a call and just let them know that, we've talked about your concerns, and
mhm,
maybe, and maybe they would feel more comfortable having a friend talk. And
mhm,
some people don't like the confrontation. I don't want my attorney thinking that I don't like him, or
mhm,
he's, and so might call a friend,
mhm,
one of us might call and say, hey, just calling for Mary, and just not
mhm,
making any assessments of what's going on here, but she's a little concerned about the relationship and
mhm,
your however you want to characterize it in a tactful way.
mhm,
She's concerned that there's a lack of communication, a lack of progress on her case. I'm not
mhm,
making any judgments, but I want you to know that. So hopefully you guys can talk and work it all out.
mhm. Yeah, and Susan's bringing up sometimes they may not even have an attorney. They may have be in a process of being
Yeah,
yeah.
yeah, you'll want to find that out.
Mhm.
I see Lori's got a point there. Would you advise against asking people to put something in writing? Not necessarily, because it could be good to write down what you remember about something, as long as you're not showing it to somebody else. If you keep it, okay, I'm writing this down in order to preserve my memory of the incident right now while it's fresh in my mind, with the thought that I'm going to share it with my attorney at a later time, I think that's probably good. Uh,
And on that point, sometimes we have cases where people are being charged. They feel like they are, unfairly being charged or treated in that charge, and then other cases where a person might be seeking that they've been harmed and nothing's being done about it, or there's not movement. So would that be similar in those two cases?
well, if you have somebody that's been harmed or believes they've been harmed, I mean, that there are a number of areas where you can refer them to. Um, Domestic violence victim, maybe the Women's Refuge could help with a restraining order, or referrals to other organizations, or maybe you would contact the police or some jurisdiction if you want to report what you believe is potential criminal activity.
Mm-hmm.
Contact a law enforcement agency,
Mm-hmm.
file a complaint.
Mm-hmm.
Those areas. But those are areas that we could help out with too. If somebody, hey, this is going on, and what should I do?
Mm-hmm.
We would have the ability to refer them to different areas without, we don't have, we wouldn't necessarily have to know the details, but just generally, what are you looking for? Well, I'm afraid this guy is harassing me. He's following me, and we could refer them to the appropriate organization.
Mm-hmm. Yeah, and that brings up one of the conversations we've had on the steering committee about making sure that we're clear about those organizations, what they currently do, and what we're going to refer them to. Like Legal Services of Northern California is coming next month to talk about what they do and don't do and who they refer to, but that seems to be definitely an area to
Mhm.
grow.
Yeah, so I'm seeing Rachel. I see your comments there, and yeah, that's right on. We got to be very careful that we don't, because inadvertently we could cause harm to them, really, when we're getting involved in the details of their case. So,
And Lori's question about knowing your rights, I'm actually much more familiar with know your rights can't, or not much more, but more familiar with know your rights campaigns for people who are undocumented. And there's some very clear guidelines. There's some that I've seen also by the ACLU in terms of knowing your rights.
right.
Is there anyone in town that does those workshops? Is the ACLU a good, and Don, feel free to.
Well, I know we used to have those ACLU cards that we'd give out to people that would lay it out. I mean, there would be
The real red cards?
Yeah, I don't know if they were
cards.
red. Can't remember if they were red or not, but Don knows.
We still have lots of cards. We have ones, know your rights with ICE, know your rights with the police department, know your rights as a juvenile, know your rights with law enforcement. I mean, we have several of them, and of course, your wallet would be bulging over if you wanted to keep all of them, but not everyone's pertinent to not every case.
Yeah, I mean, one thing that we could always tell people is don't talk to the police, don't talk to the cops unless you make sure you have an attorney. Don't discuss your case with law enforcement. Even if you 100% believe you're innocent, just don't. That's rule number one.
Mm-hmm.
You have the right to remain silent.
Mm-hmm.
I want a lawyer.
Mm-hmm.
If the police are trying to question you.
Mm-hmm.
It's hard to do, but it needs to be done. It's not easy to assert your rights in the face of a cop.
Mm-hmm. Mm-hmm.
Yeah. Because they do make you, oh yeah, okay, you got something to hide. They put pressure on.
Mm-hmm.
But that's an important piece of advice to if somebody comes to you, and that's something that I left out. But if somebody does come to you concerned about an incident that happened, you think they might be charged, well, just make sure you do not talk to the police. Even if you're innocent, stuff happens.
Mm-hmm.
Seen it 100 times, 1,000 times.
Mm-hmm. And so, and part of, I think, Lori's point here too about, and expectations, what to expect. So what should someone expect if they say, I don't want to talk to a police, I don't have an attorney on retainer, I don't want to talk until I have an attorney present. Then what should happen?
Well, they should stop that conversation right then and there. If they don't, then that's a violation of the law.
Mm-hmm.
Unfortunately, that is not always followed to a T. There's a lot of pressure that's put on. Well, you can have an attorney if you want, but you sure you don't want to talk to us? It doesn't sound like that big of a deal. Why don't we just get it out in the open here and find out what happened? I mean, you can have a lawyer if you want, but I mean, we're here right now. Let's talk about it. That kind of stuff goes on.
Mm-hmm.
It's not recorded.
Mm-hmm.
So who knows what happened?
Mm-hmm.
But what should happen is just shut it down. The cop should shut it down right then and there and abide by the request to have an attorney.
Mm-hmm. And then who do they call if they're to get connected to a public defender?
Well, normally a public defender will not be appointed unless a case is filed and they appear in court. So it may be that nothing ever happens, they don't say anything and the investigation just goes away and nothing is ever filed. If something does get filed, then they'll.
Yeah. So it sounds like first that we should be, to summarize, and I may summarize differently when I look at my notes, but we should be very careful about getting involved. Certainly if charges are either things have been filed or it's pending, we shouldn't listen to or hear any of the facts. Make sure that we're referring to them to the lawyer, let them know about their rights, let them know that they can ask for a new attorney if that's what's needed, that we could be referring to other ancillary services, that whether it's, One Safe Place does this in the community, and these other organizations are there that can help you with this. And if it's a call to see where things are in the process, that if they don't feel comfortable calling, that we could try that. People may not respond, but we could try just to give them, this is where things, here's the language to use, here's where you are.
Right.
All right, that's super helpful. That's super helpful. And I think getting some more of those cards, Don and Lee, I don't know how many you have stockpiled there, but we certainly should have a lot on hand for both for members and when we table at events. Seems like that would be great.
So would you like us to check and see what we have? And
Yes, please.
come to your house, or
Sure.
we could do that? Okay, we'll check and let you
Okay.
know.
Okay. Yeah. Thanks.
Oh, I was just going to add to Lori's comment. I see there. She's questioning if we have time, go over some other advice for victims of crime who are not being adequately served.
Yes, please.
The DA's office does have a crime victims advocacy group that I would think would be perfect to forward those inquiries to. They have victim advocates, I think they call them, 2 or 3 of them that are there for victims. And if they are the victims of a case that's already been filed, then they should contact that organization. They're over with the DA's office, Crime Victims Advocacy Group, and they take care of victims. They go to court with them. They could help them get to court. They could give them feedback on the progress of a case. They can do a whole bunch of things for the victims. Now, if the case hasn't been filed yet, then they may there's probably an investigator at a different law enforcement agency that is handling the case, and the victim could contact that investigator just to find out what the status is of the case, get an update. Normally the investigators will keep the victims advised as to the progress of the case, but never hurts to call.
Mm-hmm.
And certainly if there's any concern that a victim has over contact from the perpetrator of the crime, they would want to immediately contact law enforcement or One Safe Place or some other organization to try and get help.
Mm-hmm.
Restraining orders, assistance with contacting any harasser or anything that was going on like that, any intimidation.
I have a related question. So when I did some strategic planning for the Juvenile Justice Coordinating Council, they have to do that every 3 years. And one thing that came up quite a bit was, this idea of dual jurisdiction. The idea that sometimes, especially when it comes to youth, there are, there are things that could be dealt with by probation in counties throughout, California, or could be by children's services. And sometimes it's not clear which it should be. And, those entities can have, opinions about, well, it should be by this person or that entity. And so dual jurisdiction is an approach to working more closely together. So if there are multiple, especially for young people, entities involved, is there any place to go to who, would it be someplace, the DA brought up a lot, the DA's office, brought up the importance of dual jurisdiction. Are they the ones that would take more of a lead in helping to make sure that happens? Like who?
With youth?
When a youth is involved.
Okay. In some kind of potential criminal activity or,
Mm-hmm. Mm-hmm.
yeah. Usually that's the probation department, I think, that might get involved. And they do a lot of diversion outside of they'll look at things and say, hey, we don't want this going into the criminal justice system. This is
Mhm.
something we can handle at peer court, or something
Mhm,
we can
mhm.
just handle in maybe some counseling or community service.
Mhm.
It's a vandalism or something. They will just have the kids go up and clean this up and take care of it, and not even bring law enforcement involved. I
Mhm.
mean, a lot of times that's what happens with a kid. The cops will get involved. They might notify probation, and probation will have a look and say, this really isn't something that we want to get involved in the actual justice system. Let's just
Mhm.
work with the kids outside of this, and talk to the parents, maybe come up with a plan, just an
Mhm.
informal process outside of the juvenile justice system.
Mhm.
That's typically how that stuff happens.
Okay.
Now, if it's, it could be, like you say, child protective services, if it's something non-criminal related that was, they might get involved, or like you say, there might be dual jurisdiction, and they'll try and work on a family counseling situation and
Mhm.
bring that together.